What if fate had taken a different path in 1964, and George Wallace had actually won the presidential election? Let's say that as president, he had interpreted the Constitution, as some do today, to believe that he held the power to draft executive orders to circumvent standing constitutional law. Using the modern and seemingly popular image of executive powers, could he not have arbitrarily drafted an executive order meant to limit the effects of the 13th Amendment, thereby allowing the South to ignore the law? From a strictly legal standpoint, how would such an action have been any different than the executive orders now proposed to limit the extent of the Second Amendment? During the Civil War, the Emancipation Proclamation was an executive order meant to direct the Army and the Navy to seize the property of rebels in a time of war. Based on constitutional law, this executive order alone could not stand as approved legislation to ensure the complete prohibition of slavery in America. Based on both Article 1 of the Constitution, which vests the law-making power in Congress, and Article 2, which limits the President to an enforcement role, neither the people nor the states were bound by the proclamation itself. As a result, the 13th Amendment was drafted and ratified into law on the 6th of December 1865, after 27 states had ratified it, ultimately ensuring that the intent of the Emancipation Proclamation would be respected henceforth. Therefore, it is important to note that executive orders may only be used to direct operations within the executive branch. Any national laws meant to clarify constitutional law, according to Article 1, must be drafted and passed by the legislative branch. And, if the states wish to draft laws of their own, these laws must comply with the laws established within the Constitution as well. Traditionally, constitutional amendments have been introduced in Congress and brought before the states for 3/4 of them to ratify the amendment. According to the amendment process outlined in Article 5, neither the executive branch nor the judicial branch plays any role whatsoever in amending the U.S. Constitution. And, if necessary, the states may exercise their rights as members of the Federation to ignore Congress entirely and change constitutional law via constitutional convention. Through the convention, the states can amend the Constitution with approval from 3/4 of the states without any inputs from the federal government at all. Executive orders are no substitute for the law. One man may not simply negate the will of multiple state legislatures by pencil whipping an unconstitutional order on an impulse. Standing up for the law must be done if we are to remain a free and independent people. We are not only defending the law from encroachment by sitting presidents, we are also protecting the law to ensure that future presidents, who may be more willing to overstep the boundaries of their office, will not.